Right, good afternoon. Good afternoon, ladies and gentlemen. I think we'll make a start. Congratulations, you are officially the survivors. I'm sure there is nowhere you would rather be now than sitting listening to FATCA. You're nowhere near a lovely beach. I'm sorry? Thank you for that vote of confidence.
It must be cold in the other room then, crikey.
Because we weren't feeling fragile at all about how few people here. It's my personal ambition to squeeze a question not about the air conditioning out of one or more of you. So please, we are intent on making this as practitioner-friendly as possible, and really for that to work, there has to be some input from you. Questions, comments? Even if it's just cries for us to stop, it might wake a few of you up. We really do try and make this useful to you. If I could just briefly introduce my fellow panel members. Nick Matthews to my left, so to your right, is at the well-known firm of Kinetic Partners. Nick has worked in Los Angeles and then, fortunately for him, was in Cayman for the glory years, 2008 to 2010, and no surprise, has taken appointments as a liquidator. He's now based out of the London office of Kinetic and heads up their forensic arm and also their FATCA initiatives. On my right, so your left, is my colleague, I'm getting that right, it is quite late in the afternoon.
I'm right here.
My colleague Sean Casey from the New York office of our firm. Sean is a US trial lawyer and former AUSA from the Eastern District of New York. And fortunate as I am, if fortunate is the right word, I work with a lot of former federal prosecutors in my firm, and even a thick-skinned Brit like me has picked up on the fact that there are nuanced differences between the Eastern District of New York and the Southern District of New York. And Sean and the others from the Eastern District are much more the street fighters than the cerebral Southern District of New York. So in addition to that, Sean was, prior to then, senior counsel in the enforcement division of the Securities and Exchange Commission. So on any view, I think that makes him officially a scary person.
Formally scary person.
He's in private practice now. I am, last but not least, I hope, I am a litigator, a British barrister, English barrister by original training, and the Caribbean has been my backyard for the last 15 years or so. I'm based out of the BVI office of our firm, but I'm lucky enough to have a sort of roving brief, and I do regularly get to the smaller jurisdictions that people have been obliquely referencing today in the more macro sessions, the jurisdictions which are really feeling the brunt, the resource issue brunt, and the logistical brunt of some of the initiatives that we're talking about today. We are, find the clicker, we're going to take you through some of the fundamentals. The English phrase, an idiot's guide, doesn't translate very well over to the US, but you know what I mean. A practitioner's toolkit is really what we're interested in providing you with. And this is just a bit of a route map on where we're going to be going today. I'm not going to use its long name, it's too late in the day, but we're going to talk about FATCA and the related intergovernmental agreements. We're just going to give you a quick refresher, and Nick will help us with that. Then the scary man to my right will take over in relation to how nasty the US Department of Justice can be, in Switzerland in particular. And Nick will also then deal with the English initiatives, HMRC. I get a bit of a free pass today because a lot of the material that I feel very strongly about has been touched upon by others. If you remember earlier today, Tim Ridley in particular was sparring on this question of beneficial ownership, disclosure and things like that. But it is relevant in the context of what we're talking about today. So I'll mention that a little bit. And then some practical pointers in terms of implications for firms and investors. So that's where we're going. Please, I emphasize again, feel free to heckle at any stage. Difficult questions are welcome because I don't have to answer them, the panel members get to answer them. So we're going to kick off then with a little bit of a refresher course from Nick on FATCA.
Thanks very much. And
this isn't going to be a long technical session, and did we see that there's some IRS people in the audience over in the corner? I'm not sure if there were or not, but anyway, if there was, that's great, because my comments are going to be IRS neutral. We've heard from Tom today about Tom Lowe today about why FATCA may or may not be a good thing. We're not really going to look so much at whether it's a good thing or not. Just what is it? What does it mean for us? It's 4-year-old. It's a 4-year-old child. 2010 was when it was passed. It's barely walking yet. It's a very late developer, and it's a bit like, I'd like it to be run over by a tram. You can see the tram in the distance down the track, trundling sedately towards you, and eventually it's going to overtake us, and we're just going to get crushed by it. So it's on its way. The tram is almost on top of us, but not quite. So we'll look at what FATCA is and what the next few stops on that tram track might be. So, as we heard earlier, it's a simple concept made very difficult by 1,000-odd pages of litigation, of legislation. We heard, again earlier, 37,000 pages in the IRS tax code. Well, this is 1,000 of those. Simple concept, identifying and reporting on accounts held by US account holders. But as soon as you get past that and the withholding, you get into some complex definitions of who's covered and what you need to do in terms of withholding and so on. Just quickly on who's covered, it's banks, deposit takers, custodial institutions, investment entities, certain insurance companies as well. But the investment entities are perhaps one of the more problematic areas, because FATCA wasn't designed, I'm sure, wasn't designed for the investment world. It was designed for banks. It was rushed through. Senator Levin, God bless him, in 2010 said, let's do this, it's a wonderful thing. Rushed it all through, didn't think about the layers and layers and layers that you end up with, certainly in the investment world. And so we end up tying ourselves in quite a complex series of knots. If you are covered by FATCA, under the full FATCA legislation, as we've heard, there's registration to get your global intermediary identification number. And again, Tim mentioned earlier, Tim Ridley mentioned earlier, the beginning of this sort of insidious movement towards global numbering and being able to track things globally with these numbers. So GIN number, your GIN number is your badge of honour with FATCA. You wave it around to the world and say, look, I'm compliant, or I'm committed to be compliant, and that helps get you a long way. But with that GIN, you've got an FFI, a Foreign Financial Institution agreement with the IRS, where you agree to comply. You've got to then put in place onboarding processes that are FATCA compliant. You've got to put in a process for due diligence on your existing clients. And as we heard earlier from Tom Lowe, you have the potential for having to withhold and collect taxes on behalf of the IRS. So, a lot to it. If we go to the next slide.
Sorry, yes. I'm multitasking, sorry, I've got an iPad as well. It's very easy.
He's sending a client an email at the same time. It's quite embarrassing.
But quite complex, as I say, 1,000-odd pages of legislation. But a lot of countries thought, well, that's actually, there's some good things there. It's not a bad thing to be trying to get that information, that transparency. So a number of jurisdictions entered into intergovernmental agreements with the US, so IGAs, and these are bilateral agreements enacted through local country legislation, such that a firm that complies with the local legislation is deemed to comply with the full FATCA with the US rules.
It may, just on that, it might be useful for the audience to know whether these are pro forma, sort of one-size-fits-all type documents.
Good question. They are and they're not. There are one of the very important things about the IGAs is the fact that there are models. So there's a Model 1 and a Model 2. The Model 1 is, I guess, the most straightforward. And the good thing about the IGAs is they simplify FATCA compliance for the IGA countries. Both the Model 1 and Model 2 do away with withholding, and that's a key benefit. But the Model 1, once you've registered and got your GIN, you're then just interacting with your local tax authority. You're reporting to your local tax authority, still reporting US accounts. And again, some of the scaremongering around this was reporting your account, all the accounts. You're only reporting US accounts here. And then the Model 2, which is the other pro forma model, is a bit of a hybrid between the US legislation and Model 1. You're contracting with the IRS. You've got your FFI agreement. you're reporting to the IRS, but again, you're still not withholding. So but the fact they're models brings some predictability in. But that said, the models aren't entirely applied as written. So when each country enacts one of these, they'll take in particular Annex 2, which is some of the detail behind it, which specifies for that particular country which of their types of entities or which type of account might be outside of scope. So, for example, Luxembourg, when they executed their IGA, they specify quite a lot about Luxembourg SICAV structures. Or Australia has put in quite a lot about the Australian superannuation schemes, just to clarify that those would be, although sort of covered by FATCA, they become non-reporting parts. The other important thing about the IGAs is just they're simpler. They're, instead of the 1,000-odd pages, they're about 40-odd pages long. They're far more accessible, far more user-friendly. They come with some guidance from the tax authorities that issue them, and for the likes of us that have to enact it or put it into place, far more easy to understand. Don't worry about the detail on this slide. The purpose for this slide is just to show, bang, there's a lot of these out there. This is the green are countries that have got an IGA executed already. The grey are countries which have committed to have an IGA in place. There's 50-odd Model 1 and 5 Model 2 countries on there. That's actually even changed since I did this on the 28th of April. Australia and Belgium would now have gone green from grey. So it's a very dynamic situation. Again, it just shows just the importance of the IGAs. They bring that predictability. The model, even those countries that haven't yet got their IGAs in place, you know more or less what they're going to say because of the models. So that's a very, very important part. Some key dates. Can't have a refresher on FATCA without some key dates. You'll be familiar with these. This is our tram timetable coming down the track towards us. The second one down is worthy of mention. Until very recently, that would have said 5th of May, today, being the deadline for registration to be sure you get your GIN before withholding starts on 1st of July. Practical reality has overtaken. GINs are being issued a lot quicker than they thought they might be able to. So applications for a GIN on the IRS website tend to have been coming through in matters of days now rather than the several weeks that were originally anticipated. So the smart money now is really saying that 3rd of June is a good, if you're registered by the 3rd of June, you'll be fine for not being withheld on from the 1st of July. And then even some of these dates are a little bit softer, or a Model 1 IGA country, if you haven't got your GIN by the 1st of July, you can survive without it till the end of the year. So they're not quite drop dead, you're going to get fined type dates.
But are they, I mean, we've all seen them moving regularly. Are these the best guess that you have? Are these going to stay in place?
I've been wrong before, but I think they probably are. The reason I say that partly is because even on Friday last week there was call it a relaxation. The IRS issued Notice 33 of 2014, which allowed for a couple of changes. One change to how you deal with new entity accounts. We don't need to go into detail, but gave a slightly longer grace period for dealing with entity accounts, but also brought in a good faith defence, if you like, that basically firms that have made a good faith attempts to comply with FATCA, the IRS will take that into consideration. Now, the cynic would say, and far be it for us on the panel to be cynics, that perhaps this is helping the IRS get up with it as well as just firms. The IRS is going to struggle as well, I think.
And I think it would be useful just to hear a little bit. I think it's on your next slide about initiatives outside of the US.
Yeah. So I guess the UK was the first to think this. The cat was out of the bag as far as information exchange was concerned, and maybe this transparency is a good idea. Let's have some of that tax information about our own taxpayers. So in the course of last year, the UK cajoled, persuaded, agreed with Crown dependencies and overseas territories to have IGAs between the UK and the Crown dependencies and overseas territories. Crown dependencies, so Jersey, Guernsey, Isle of Man, Gibraltar, are reciprocal, so that UK entities need to prepare to give information on their taxpayers back to those jurisdictions. The overseas territories, where there are no tax in the first place, they're one-way, non-reciprocal agreements. But the important thing for people in the room here, of course, is a lot of BVI or Cayman or other offshore entities will be caught by this as well. So it's not just now about collecting US information, it's now about collecting information on UK taxpayers as well. And yeah, it's the beginning and not the end of proliferation. That's enough from me, I think.
we're just about to go on to Sean's part, but before we do, it occurs to me, my enthusiasm about telling you what he used to do, I failed to tell you what Sean currently does at the firm, and very mindful of his Irish temper, I just want to get that clear. Sean is one of my colleagues who specialises in white-collar and regulatory enforcement, and an increasing aspect of that side of our firm is that it involves the offshore territories and places where there are high net worth structures. Okay, there we go.
So I think it makes sense to start with what the U.S. has done to Switzerland, because that forms the basis on what we're going to predict going forward for the other offshore jurisdictions. Because what's going to happen is, through the Swiss process, the U.S. has gotten their hands on a huge amount of information about non-compliant U.S. taxpayers. Then FATCA is going to kick in, and over the years, they're going to get an even larger amount of information on non-compliant U.S. taxpayers. So the Swiss lesson sort of teaches us two things. One, how the IRS and really the DOJ are going to act going forward. But two, what do they already have on people in the Caymans, in Bermuda, in any jurisdiction, in Hong Kong, and how they might use it, because they're using it very effectively right now to charge people and bring cases and bring numerous banks to their knees. And it's a lesson learned. We should probably go to the first slide. Oh, sorry.
It's all right. He's obviously above using it.
So, some recent history first. In 2008, there was a Senate subcommittee investigation that sort of shined the light on the fact that at least certain U.S. senators believed there was a lot of people avoiding their taxes, paying their taxes in Switzerland. So that caused, they pushed the Department of Justice, and the Department of Justice brought a series of cases. You're familiar with them, but the biggest one is the UBS case. In the UBS case, that sort of started this entire flow of information, because for the first time ever, as part of that settlement, the UBS was required to turn over the names of account holders in Switzerland. That's a new thing. 4,700 account holders, their names were provided. And that's a sea change in things that had ever happened before. And it caused, in our view, and we see this from the other side, and we have friends that are or current prosecutors also, that caused this massive amount of panic. And the panic didn't really have a place to go until what's called the IRS Offshore Voluntary Disclosure Program. Everybody who had assets offshore in Switzerland or elsewhere were presented a very good opportunity to go into the voluntary disclosure program, say everything you know about who helped set up your offshore bank account, your offshore investment account, your trust, any of your advisors, and essentially become cooperating witnesses against the people that were back in the United States. I'm sorry, back in Switzerland. You had to say you were sorry, and you had to pay a very large fine. But for the most part, these people avoided prosecution. Since then, so that spark caused not just those 4,700, but since then, as you can see from that top box, recently reported 2 months ago, 43,000 U.S. taxpayers have poured into the voluntary disclosure program. That's 43,000 witnesses against people who are helping people keep their money offshore, which, by the way, is not necessarily a crime in any form. It's just, that's the way the U.S. government views it. So what you have here right now is a lot of cooperating witnesses, rats, snitches, however you want to call them, they're now working hand in hand with prosecutors, and they're building cases, and you've seen the cases. Since then, since UBS, you see some people at Credit Suisse, ZKB, a whole bunch of other Swiss banks are either in the process of getting charged or in the process of turning themselves in to avoid getting charged. And we'll talk about that in a second. But that's just going to yield more information and more success for the Department of Justice.
Okay, next.
Yeah, let's go to the next. So this is sort of how the prosecutors are going to build their case. Obviously, the Offshore Voluntary Disclosure Program is a big piece of it, and that's where you start. And there's an FBI agent who's going to speak tomorrow here, and I was talking to him, what could you do with 47,000 cooperating witnesses? And he said he could take over the world. And obviously, that's what the United States is seeking to do here. The other two pieces of valuable information they get are something called lever lists. Lever list is a creature coming from, there's a program for the Swiss banks if they want to turn themselves in, if they want to seek a non-prosecution agreement or a non-target letter, they have to do their own internal investigation. And there's 104 banks currently doing this. Doing their own internal investigation and reporting certain facts to the IRS and the Department of Justice. They're not going to give over account holder names, but they're going to give a huge amount of data, and then they're going to pay a fine, a large, probably multi-$100 million fine, based on how many accounts they had that were non-compliant. But the lever list is sort of the clue as to what the U.S. is going to do next. As a condition of getting your settlement, you had to provide the information as to where the funds left to. Like, that's where you get where the levers. The levers went from Switzerland, and where did those funds go? So this is sort of our first clue as to what's the Department of Justice going to do. They're literally just going to follow the money, because they're going to get the amount and by month how much money went to each jurisdiction, wherever it went across the world. And if it came to the U.S., they probably won't get prosecuted. The last piece is John Doe summonses. They're out there. You've probably heard news of a few of them. The Cayman Bank and another Swiss bank received one a few months ago, and then Citibank and a bunch of other U.S. banks that cleared for these counts also received John Doe summonses, which required the disclosure of names of U.S. account holders. All this is doing is feeding this massive panic and creating this huge success for the IRS and for the Department of Justice. Let's move on to the next. This is a little more granular on these two pieces of information. You don't need to be Sherlock Holmes to figure out. That top box is, if you enter the voluntary disclosure program, you have to complete question 5 and about 6 other questions that ask for the same exact information. Basically, you have to turn over the individuals, what banks you used, who are the financial advisors, who are the corporate service providers, and give us the communication record on all of them. They're going after those people. They already are going after those people. And the lower list is the lever list. I mean, the lower box is the lever list. That's where how the IRS is going to trace the money onto the next jurisdiction. It's important to understand these people. There's been 34 people charged, probably 36, because this was updated a couple days ago. These are regular people. I have a handful of clients that were financial advisors in Switzerland, completely compliant with Swiss law, not doing anything wrong at all, and now they're charged. And for the most part, they're safe in Switzerland, we think, but they look like you guys or your clients or your colleagues. They were people who were in compliant with their local law, and then one day they read in the newspaper that they were indicted in something called the Southern District of New York, of all places. It's a somewhat of a tragic story because they're trapped in Switzerland for the rest of their lives. They're obviously worse places to go, including a federal penitentiary. But it is one of these things that the U.S. is just sort of seeing that and getting this success. But it also turns into a massive fundraising mechanism, and Congress sort of feeds off this because about $6 billion in taxes have been paid. And then when these Swiss banks start paying in their fines, it will significantly amp up that number. Let's go to the next. These are just some of the statistics I've been glossing over. 134 indictments. Now, a huge amount of that are U.S. taxpayers. The 43,000 in the Offshore Voluntary Disclosure Program, but that number is likely to go up also. The 106 requests to participate in this program, that's the program to get a non-prosecution agreement. That's going to yield a whole bunch more information for the IRS to sort of move, because most of this money is still out there. Most of it has not been repatriated to the United States. So this is more the beginning of what the IRS is going to do offshore. The 14 banks that were under investigation are not permitted to enter the program. So they just have to sort of stay and wait till they get indicted. And you've seen a bank get indicted and sort of get wiped off the face of the planet. And that's where we are. A couple questions that come up are that people have, and I've spoken to people in various islands, and they say to us, you know, we're not the Swiss. This isn't going to happen to us because, you know, we complied with our law and we didn't do anything wrong. A word on that is it's extremely unfortunate, but the Swiss didn't think they were the Swiss beforehand either, and now, you know, they're largely stuck in their country. This last piece is to show sort of how backwards the government, my government is right now. This is a massive success for the Department of Justice, you would think. Huge amount of money pouring in, big publicity. This is from Senators McCain and Levin last month. Even after all the success, they put out another investigative report, which was just belittled the Department of Justice efforts over about 70 pages of text, saying how weak they've been, how lax they've been, how they're letting the Swiss push them around. And so you see this sort of agony that a lot of Swiss banks have been put through, and at least the Senate doesn't seem to think that that's there. The reason I say that is there's also a second question that the U.S. just doesn't have the ability to prosecute all these cases. You know, there's a resource problem at the Department of Justice. There's a hiring freeze there. There's a hiring freeze, I think, at the IRS. There are certainly problems at the SEC. The people who control how big the Department of Justice gets are those two guys that signed the bottom line there, and obviously a few other senators also. But they're going to get the support to bring these kind of cases, and they're going to continue to sort of push those cases forward, and whether it comes down sort of south of Miami or over into Asia. But these are coming.
I have a question for both Nick and Sean that may be useful to hear the answer on. As a sort of medium altitude view, it looks like there's a difference in approach. The US, on the one hand, targeting the gatekeepers of information, and on the UK side of things, it seems to be more specifically orientated at the taxpayers themselves. And would you broadly agree with that?
Yeah, that's right. I mean, we're a bit more British about it, I suppose, over there. Not quite, not necessarily going after the banks and the bankers, but going after taxpayers.
Well, we're going to move on now to the corollary. Whoop. Wow. That wasn't just in my head, there was a noise there.
No.
Right. Okay, so we're going to look a little bit with Nick now at the HMRC disclosure facilities.
Yeah, so this is the British approach. And if McCain and Levin didn't like what the US DOJ is doing, they certainly probably won't like this, because not really targeting the banks and the bankers, but really going after the taxpayers. But looking at other things as well, looking at not only the criminal side, but maybe trying to change behaviour through non-financial sanctions such as naming and shaming, trying to encourage some whistleblowing. And the UK, as you may know, the UK has never really been championed rewarding whistleblowers for blowing the whistle. Now they're starting to think about that, not only in this context, the tax context, but other parts of law enforcement as well. So the UK has got a big focus on tax evasion, particularly offshore tax evasion, but also is also picking up on avoidance issues as well. So very much a focus on both sides. On the avoidance side, obviously working still with tax advisors on their various tax plans and tax schemes, but in the finance bill that's just gone through now, there's provision for advance payments of disputed tax money, and then you then appeal, and then you try and get that money back. So trying to get the money into the UK government's coffers earlier rather than sitting in the taxpayers' bank accounts. So yeah, as I say, a different approach, but the key thing is really the disclosure facilities. There have been some more inquisitorial approaches, so some production orders, but the disclosure facilities are by far the key thing for the UK HMRC. At the bottom, actually, we'll go to the bottom first, which is Isle of Man, Jersey, Guernsey disclosure facilities. Possibly, and there's been talk about there being a Cayman facility on the way, perhaps. But these are facilities for a bit like the disclosure facility that Sean mentioned. facilities for taxpayers to regularise their affairs where they've got hidden assets in these jurisdictions. And that's all well and good, but perhaps more interestingly is the Liechtenstein facility. Quite a groundbreaking piece of legislation in that although it's a Liechtenstein facility, it's actually a global facility. It's open to taxpayers to use the Liechtenstein or Liechtenstein bank account as the nexus for regularising their global tax affairs. Open account in Liechtenstein and use that to come clean to the HMRC. And importantly, it's a guarantee against criminal prosecution as well to go through the LDF. So if you see, you've got the disclosure facilities persuading people to come forward, persuading the taxpayers to come forward, at the same time as having the soon to come with the Crown dependencies IGAs that we spoke about earlier, where this money will be provided by the Crown dependencies and overseas territories to HMRC in a year or so's time. It's a sort of Twin Peaks approach to target those taxpayers to get them to come forward. And there have been some successes. And the first line up here, I think, puts the US poultry, 46,000 or 43,000 you had, Sean? It's a shame.
Yes.
56,000 taxpayers, HMRC say, have come forward through the disclosure facilities.
It's because they don't get hurt when they come forward in the Great Britain.
Quite possibly, yeah. They haven't then got to go and sort of turn evidence on their favourite banker. And £1.5 billion, so what's that, $2 and a bit billion of offshore tax money is recovered, which isn't bad in a population a fifth the size of the US. So some not bad results there from these facilities. And then looking forward, HMRC is very excited about what's going to happen next, which I think Tim's going to talk about.
Yes, I'm just going to touch on some of the things that were spoken of in greater detail in various different talks today. And the relevance to this discussion is, of course, this is going to bring on stream a whole raft of additional information. I have a major conceptual question over whether or not it can actually be handled if and when it is competently created. So it really isn't a question of whether there is going to be automatic exchange down the road. It is going to happen, and the infrastructure is in place. The common reporting standard that the OECD has pumped out has been out and agreed by a large number of people. But let's just have a look at automatic exchange of information. Just let it sink in what it's going to be. It's just going to happen country to country each year without the need for a request to be made. Just think of the infrastructure that presupposes in some of the jurisdictions which themselves are currently grappling with, well, FATCA, for example. Just think of how realistic a prospect it is that they're going to be able to cope with this. So if one looks at the context of this, my number of tiers is actually low. Alex Potts gave a higher figure of just over 1,200, but the fact is there are a large number of bilateral agreements already that underpin the sort of goodwill that is pushing people towards automatic information exchange. And it is an interesting issue as to how much of this can continue to go on and yet leave at the same time supportable as an argument that the revenue rule, the fact that one sovereign nation should never enforce another sovereign nation's tax debt in that country, how long is that going to survive when these inroads of this sort of size and magnitude are being pushed forward? It's a very insidious way of getting there as well. Obviously, it can't be seen to be the developed countries forcing this infrastructure on the smaller territories. It has to be peer review led so that those really driving the bus can say, well, your peer group have all said that you're deficient. Your peer group have all said that you need to improve. And that's what the peer review is really about. If you fail, you're not failing to the standards of America or Britain. You're failing to what is purported to be a global standard. And the OECD based in Paris does good work for the larger onshore countries. In terms of the actual mechanism for automatic exchange of information, I mean, I'm not sure everybody realises that if you open a bank account with member states, those who've signed up, from the 1st of January 2016, part of the application process to open that account is information about your tax residence. There will be no way to open the account without disclosing that, because that, of course, sets up the mechanism for them as the financial institution to know who they would report back into. And there is a transitional period for current accounts that are of a certain threshold amount. The high value status of an account, which would accelerate the timing on getting this information in place, is at a relatively modest 250,000 US. So you can see a whole raft of accounts that aren't being opened as new accounts, but that pre-exist, are also going to have to be brought into this scheme. And someone speaking earlier today made the point that it's one thing having new clients come in the door and learn that if they want an account, this is what it has to happen. It's a wholly different thing from a client-customer perspective, explaining to people who've been with you for X number of years that this is what has to happen, even though they've had a trouble-free relationship.
Can I just interrupt there, Tim?
Yes, go ahead.
But just on that point about new accounts being opened and capturing that tax residency information, in fact, it's going to happen a lot sooner than that, because with the UK IGAs, but also given that firms are already having to put in place FATCA compliant and UK FATCA compliant onboarding processes, really now firms, banks and administrators are going to be asking for that tax residency information from the 1st of July this year, because you're basically future-proofing it, so that you haven't got to go and ask for it again, as you say, in 18 months' time. So actually it's going to start sooner than that.
Well, one of the interesting missing countries in the Common Reporting Standards, and this isn't sort of a talking forum that they're negotiating. This is a standard that's been adopted pre-implementation. The US are absent from that list of common reporting adopters. But the ultimate penalty, or the coercive threat to this, is that by the end of 2015, the G20 are threatening sanctions against anybody who doesn't sign up. So what choice do the smaller jurisdictions really have? They've spent so much time signing up to bilateral tiers to get off blacklists. This is just yet more of the same. So it is absolutely going to happen. And then for those of you who were at the tier-specific litigation lecture a couple of lectures ago here in this room today, there are clear issues on automatic exchange about who gets the right to challenge the fact that this information is going backwards and forwards. There's no interposing of the account holder in this process. The information just ends up back in their country of tax residence. And if one reads the Common Reporting Standards process, it talks merrily of them bundling up and encrypting and sending country-specific information from one tax authority to the next. Well, where are these various apparatuses in these smaller jurisdictions? Who is going to staff this process when they bundle together, it's their choice of word, all of the information that needs to go back to the United Kingdom? How do they expect that to happen? And are we going to have a repeat of France's attitude, where they criticised some of the overseas territories and blacklisted several of them because of the speed at which requests on bilateral tiers were being reacted to? What happens in a situation where, through no fault of the individual account holders, the information just isn't collated competently and isn't provided on a timely basis? Is that person themselves going to be subject to a IRS or an Inland Revenue investigation? So there are some really serious resource issues. And then finally, just on this question of beneficial ownership, I heard what Tim Ridley said, that there are plenty of miles left in this. I disagree with him if he's intending to say or mean by that there is any question whether or not this is going to happen. It's definitely going to happen. There are some problems in terms of trusts being left out of it, and how one can effectively frustrate the purpose of it, but there's no question that certainly the overseas territories are being coerced into doing it. I mean, one only has to look at the truncated time period for the so-called consultation period in the Turks and Caicos. David, you'll correct me, but I think it's about 3 weeks or something. I mean, it's a nonsense. And the consultation will clearly come out with a, well, we'll have to go along with this. So there is only lip service really being paid to the consultation process for beneficial ownership. And again, same issue in relation to automatic exchange of information. Who is going to staff responding to any of these requests? The wheelbarrow of information, as Tim Ridley described it. And there are obviously pretty serious macro effects for the industry, fiduciary industry as a whole. I think we have some tips generally. If we go to the next slide.
Well, just before we go on that, just we don't need to go back to the slide, but yeah, I mean, that point about the industry having to deal with this. For example, the OECD Common Reporting Standard is based on, as I said earlier, the very important Model 1 IGA, but it's not the same. There's some subtle differences. There's no de minimis for individual accounts that there is under full FATCA. You've got no carve-out for regularly traded accounts. Under full FATCA, a financial account is defined as, among other things, an investor in an investment entity, unless it's a regularly traded instrument. That's not in the Common Reporting Standard, but the Common Reporting Standard is not going to change. It's been agreed. So all it's left with is the likes of HMRC or other local tax authorities having to sort of retrofit through their guidance and what they expect, some ways of actually allowing their local industries to be able to survive this, because it's just those subtle differences. If you're not careful, will trip people up, will trip firms up.
Well, we have some practical pointers. I think, Sean, do you want to jump in on some of these?
I mean, these are some things that you should think about either advising your clients or your institutions before either the IRS, Department of Justice, or the Brits show up at your door. And these are things that we've seen people do successfully, seen people fail to do, and really cause a huge problem for themselves. The first one is obviously take a look at the taxpayers that have left. Taxpayers that have left in the past or that are still there, to get an assessment of actually if they hadn't paid their taxes, and you might not know, but if they hadn't paid your taxes, what kind of liability does your firm have? Because one of the places that the prosecutors like to go are to big banks or easy cases to bring. But if they can find an easy case against a bank or a huge amount of money, they'll go there first. So if you're sitting on potentially millions, tens, 20 millions of dollars that haven't been reported in taxes, that's something you want to know before you receive a John Doe subpoena. You want to know that before one of your financial advisors flies into Miami International Airport and gets arrested. It's one of the things that people sort of are keeping their head in the sand a little about and could really learn a lot about their potential exposure before, if they have any at all. Piece together the communication record and train employees how to communicate effectively. This is serious now, because you do have these 40-odd thousand people out there that are trying to work with the government. Now, the U.S. government's probably not going to call someone offshore and record them. They just don't do that, and not often permitted to do that. But there's nothing preventing a non-compliant U.S. taxpayer that's about to turn himself in from calling up your banker and recording that conversation, and having one of your employees or one of the employees of the firms that you represent saying something stupid on tape about taxes, about how they're not paying taxes, about how the United States government is overreaching and they shouldn't get their taxes. Because those type of recordings are the things that make trials and make prosecutors sort of get excited, because it's so hard to do. A tax case is not the most fun thing to do in a trial because it's mostly paper. But if you can get a recording in there, and they would like one, you would want to avoid having your employees say things that they would regret to hear while they're sitting on a stand somewhere. Some of the other pieces are, obviously a lot of money is leaving Switzerland now. So it's going somewhere. If it's coming to a jurisdiction where you're familiar with the people there, if there's new money coming in, it'd be a good idea to figure out where that money's coming from. Because if the IRS will, or the Department of Justice will be right behind if that money is leaving one of these banks that they're currently prosecuting. It's a trail that's almost too easy to follow. The last piece is taxpayer specific. We're obviously not giving any legal advice, and each case is different. But depending on facts or circumstances, taxpayers seem to be really winning. So if you can get, if you have a taxpayer, it might be a good idea to go into one of these disclosure programs. The question we get, which is a much harder one, is if you have a firm that has a dozen non-compliant taxpayers or years of people not reporting their taxes, and the firm could look like they were enabling or aiding and abetting that firm, what do? Do they turn themselves in? And I think in the U.S. you get a lot of cookie cutter advice from lawyers saying, always go in front of the Department of Justice, because you get some sort of cooperation credit. Possible self-disclosure is an option. It's just not the first option in most cases. Obviously, each case differs slightly. But oftentimes people have to really assess those first couple points. Did our employees say anything stupid? How big of a problem do we have? Before they go running to the Department of Justice. And I would strongly advise sort of thinking twice, 3 times, even 4 times before calling up the U.S. government yourself. Because there is credit given, but it's few and far between. That's the struggle that many firms have now, that they're starting to find out, oh, we've had a bunch of U.S. taxpayers in here and they haven't paid their taxes in years, and maybe we're in trouble. With that, we open up the floor to any questions.
Well, hang on.
Oh, I'm sorry.
Britain hasn't finished.
I'm sorry. So American.
Waiting politely, being very British over this end of the table again.
Paradigm example.
No, I was just going to, again, slightly contrast the disclosure facilities point that Sean just mentioned with the disclosure program. The Guernsey, Jersey, Isle of Man disclosure facilities do put a requirement on the banks or the institutions to identify taxpayers or clients who may be relevant to the disclosure program. So there's a taxpayer end of it, i.e. they can come through and use the program, the facility, but also the bank's end of it is make sure they've got to take efforts to clean up. And again, it's not just US taxpayers, it's just clean up their taxpayer base. Because ultimately, of course, the banks want to continue in business, they want to keep their clients, they just want to have clean clients. So, and that's why there's an element of the banks have got to do something, they've got some onus under the disclosure facilities. And then the other obvious thing up there, I mean, with our 1,000+ pages of FATCA, then it is very, very complicated. It affects different firms in different ways for the investment world. In a way, it's a lot simpler than it is for the banks, clearly. I mean, the investment firms will have fewer account holders, generally fewer investors than the tens of thousands of account holders that a bank might have. You'll have fund administrators that will probably know a lot more about the investors from word go, because they've been doing the onboarding, and the administrators will tend to be the ones that do it. But the key thing is make sure that the administrator, the directors, the managers know which of them is expecting the other to do what, because you don't want to put things falling between the cracks. So have those conversations are very important. A lot of the minutiae, the detail of full FATCA falls away because of the IGAs, which is great for the investment world, and you haven't got to worry about too much detail, but there's still a lot of information, a lot of detail to still wrestle with as far as what's in scope, what's out of scope, which type of accounts you report, and so on. So have those conversations. The administrators tend to be all over it by now.
I'm acutely conscious that school is out after this, but please, I will personally bring to you one of the free cocktails if I can extract one question, at least one question. So come on, humour us. Has anybody got a question before you leave? End on a high. Ah, right. Thank you.
The taxes with the HMRC, when you do the taxes for, you said earlier, similar to the FATCA.
Yes.
The government is doing something similar.
Yes.
Does this include UK citizens living abroad?
No. No, so the US, as you truly know, is virtually unique in the world of having a citizenship-based tax regime. So the UK is a residency-based tax regime, so it's only to the extent that they're emitting into the UK, I believe. But basically, no, simple answer. Before I tie myself in knots, because I'm not a tax advisor, I'm a FATCA person.
I would agree with that, yeah.
when is a US citizen not a US citizen for purposes of FATCA? Is a person who has, I heard an example last week, a Brazilian passport which bears their place of birth in New York City, the United States citizen for purposes of FATCA?
Yes, they are.
Yeah.
So they can renounce the citizenship.
So presumably, you need evidence of them having renounced their citizenship.
And having paid their exit tax.
And it is not an easy
It's an
process
ugly
to renounce
process,
your
really.
citizenship.
And the exit tax, is that based on the net worth?
It's a deemed disposal. You're taxed as if you're disposing of all of your assets. So you keep your assets, but you've taxed on your entire net worth. Yeah.
So really, I mean, being alert to, particularly with United States citizens, isn't in itself enough, I suppose, for FATCA purposes, because the bearer, the person, the client, may not hold a US passport. May not be aware of it.
Yeah, there's a test. There's a test in the Swiss program, the 7 indicia of U.S. U.S. citizenship or U.S. indicia on the account, and it goes way beyond the passport and where the powers of attorney are. Are there any mailing addresses within the U.S.? So does somebody get a check once every 6 months? A child maybe even. And any mail going into the U.S. Any mail that's actually held, even if it's held in Switzerland, but held. That's some indicia that the person's from the United States, which is somewhat baffling.
Those are echoed in FATCA as well. You can cure them if you come up with one of the indicia is hit, you can cure the indicator by providing evidence that that was true then, not now. I mean, the hardest one is obviously the citizenship point. Right. The other thing to say though is, for FATCA at least, I'm not sure about the disclosure programs, but for FATCA you haven't got to proactively make sure that that someone is not also holding a green card or haven't got dual citizenship. If the information you've got on file is AML compliant and doesn't suggest otherwise that they are in fact a US person, you haven't then got to sort of cover off and prove the negative.
Yes, sir.
Would you not have the same problem with UK FATCA as far as residency goes? Because
Yes.
the Inland Revenue have issued a long lot of guidelines. And I know several people who think they're not resident, in fact are.
That's correct.
That's
yes.
absolutely right. Although it's more benign than the US, since the Gaines-Cooper case, and the information that you've indicated, the test, it's a much stricter regime. It's much more difficult to play that game in the UK than it once was.
There was a discussion earlier in relation to financial institutions who have banked American clients who may or may not have paid their taxes and what the liabilities are for those financial institutions. What is the test between a bank that has American deposit holders that haven't paid taxes in the past, as opposed to financial institutions that have American deposit holders and have aided them in not paying their taxes? Because surely you can't go after every bank in the world that has an American deposit holder who hasn't paid taxes. Because it certainly wasn't the financial institution's responsibility to ensure that you were in their cut. So there must be some threshold or some gauge that says these boys just house deposit holders and these fellas are actively engaged in assisting them in avoiding taxes.
You would think there would be. Within that program, the Swiss-US program for non-target letters, there is a conduct review that goes on. So one of the things you have to do is hire an outside law firm to do an independent review of the conduct of sort of the financial advisors within the bank and report that to the IRS. Within there, you're going to see people are going to be making calls between, in that gray area between, this was intentional conduct or this was just somebody not, a banker maybe not asking for the correct U.S. disclosure forms or the correct U.S. tax forms or the FBAR or whatever it is. But I'll tell you, we've seen people get indicted. There's a public indictment out there of a banker in Switzerland. The only thing he did, now, according to the indictment, is he allowed the U.S. taxpayers to use either numbered or coded accounts rather than using the account holder's real name. Now, you're sitting here waiting for me to say what else. There is nothing else. Like, he didn't do anything else other than use the numbering and the code name account that the bank had been using, my guess, since the turn of the century, and the turn of the other century. And that sort of conduct, that guy's indicted. Like, he's literally thought to be a criminal in the United States. So there's not a test yet developed, and oftentimes you won't see a test as to whether or not you're just, maybe you were negligent or something like that, rather than grossly negligent or reckless. But right now, I don't see a clear dividing line.
So the long and short is, any financial institution that has had American deposit holders and don't pay the taxes, they're likely to be indicted?
No, because they can't. Even in Switzerland, they couldn't do it. So they set up this program. So they're probably going to indict a couple more. But these 104 banks are avoiding indictment by turning themselves in. So they can continue to exist. They're going to pay a big fine. They're going to do a big report to the DOJ tax and the IRS. I don't believe they're going to be able to indict everybody. They're just not. They don't do that with any crime. Even in the United States, they don't do that with any crime. They do what they did to Martha Stewart. They take a couple big cases, a couple like well-known things, and hold them up as an example and say, look, if you lie, this is the Martha Stewart situation. If you're caught in an SEC investigation lying, we're going to charge you. And people see Martha Stewart gets charged. So everyone's like, well, if she got charged, they're going to certainly could charge me. It's sort of how the theory of federal prosecution is make an example of a core group so that then you can not prosecute everybody else.
Go ahead, yes.
Can I weigh in on that question for a moment? My firm is involved with representing a financial institution that's not in the U.S. and that has been told by the American authorities that it's the target of a criminal grand jury investigation. And I've wondered these same things. Even though I'm a former federal prosecutor, I wondered the same things. I didn't know where the line was. And what I'm hoping is true based on my research is that, first of all, if you're going to charge somebody with a U.S. tax crime, you have to prove that they were willful, meaning that they knew that there were certain tax obligations and that they chose to violate them. What would that look like in the context of a bank? Well, unfortunately, under U.S. federal criminal law, an entity is responsible for the actions of any of its employees. Doesn't matter if they're a control level employee or a janitor, if the action the person took was they at least thought was to help their company. So obviously, any big institution, you're going to have people doing things that you wish they hadn't done. And then I thought, well, what gives the U.S. the right to go after a bank that doesn't do business in the U.S.? Well, the U.S. courts, again, this is all subject to my, so-so legal research skills, right? The U.S. courts have said to get jurisdiction over some body or something outside of the U.S., leaving aside whether there's a statutory provision for it. But under the U.S. Constitution, it suffices for due process if that entity or bank had minimum contacts with the U.S. That, in turn, has been interpreted to mean if they are directing their behavior toward the U.S., meaning if it was reasonably foreseeable that their behavior would have this impact on the U.S., they are then within. And the case that really blew it away for me was, and I'm probably getting this wrong, but there was the courts in the U.S., I think it was up in Sean's neck of the woods, said it satisfies minimum contacts that a guy, a non-American sitting in Italy, paid a bribe in his company that violated Foreign Corrupt Practices Act, and his company was it was going to have an impact on the stock price of a company that was listed on the New York Stock Exchange. Therefore, he could reasonably perceive that the bribe that his company paid in some third country that's not the U.S. would have this impact on the U.S. Therefore, it is within U.S. jurisdiction for the U.S. federal prosecutors to go after his company that's, say, in Italy or whatever. So it comes down to what bank is really willing to challenge all of these points in a U.S. court. What bank could withstand being indicted to then go make these arguments in a U.S. court?
Yeah, that's right.
Probably not many. So these things may never be tested. The only time they get tested is when the American authorities prosecute an individual, because an individual can go and fight and isn't going to go under, so to speak, assuming they can afford to do it. I don't think you're ever going to see a bank stand up and say, okay, prove all these jurisdictional theories you have, and prove that, my one guy in my trust subsidiary who said, A, don't worry, we'll use your Brazilian passport instead of your U.S. passport, that should go all the way up to the bank. I just think that nobody's in a position to have that fight. So you instead have a very delicate dance with the federal prosecutor and try to be as cooperative as you can in exchange for hoping that you get a penalty that won't kill you as an institution. That's my pessimism.
Just in case you're worried, those are the end of the slides. We're nearly halfway. David, sorry.
Can I ask about, I haven't read I confess I haven't read the Model 1 and 2 IGAs, but do they include a commitment by these jurisdictions to amend their confidentiality laws locally? Because obviously, certainly my understanding of the Social Security is that the government is talking about amendment to its own confidentiality legislation to provide immunity from both criminal and civil liability. I haven't yet seen a draft like that, but presumably the US IRS doesn't give a monkey.
Well, no, it doesn't. I mean, partly why the Model 2 was created was to give a route through for jurisdictions with more stringent secrecy requirements to report a limited amount of information to the IRS, and then the IRS will then go to the tax authority in the jurisdiction for the rest of the information. The other thing with the Model 1 IGA is you're providing the information within the same country. So whether that avoids some of that, you're not providing it outside the country, then it's provided by the authorities. But no, simple answer, it's not in there. I think there might be something there's some sort of overriding language that talks about the governments will look into it and do what's necessary to make it happen. Data Protection Act in the UK, is a similar sort of thing, and the HMRC essentially said actually that whether or not we need to change the DPA, don't know, but probably you can get around it anyway because there's a avoidance of crime element in the Data Protection Act, for example. So we've even been starting to look at that and say, well, maybe disclosing using that carve out under the Data Protection Act would be enough. But like public policy wise, the Office of Information Controller in the UK is saying we're not going to prosecute someone for complying with an IGA, even if strictly speaking that it's outside the law, because it's not in public policy to do so.
Don't forget, David, the legislation that you're thinking of still requires the Attorney General's fiat to prosecute a breach of the Confidential Relationships Ordinance. And I've been in this situation before, because you're absolutely right to be worried. There is no flexibility in that legislation. And it's pretty unsatisfactory to try and tell a client that the AG will probably never prosecute.
Yeah.
I mean, that's exactly why Section 4 of the Cayman Law got amended like that, to give the flexibility of being able to go to court.
There's a question back there on the glow of the light. 2.
Somebody over there, sorry, we can't see you very well.
at all.
Practically blinded with glasses.
There's one in the back corner as well. But
Are there any provisions for dual citizenship so that we don't have the UK and the US chasing the same people?
Only through double taxation treaties. So there is a concept. Yeah, certainly it's accepted that you may end up being caught by both. On the flip side, you haven't got to explore whether someone's dual. So if someone's given the French passport rather than the US passport, then you haven't got to make sure they haven't got a US. But it might well be you're caught by both, and then it's just a question of double taxation treaties and reclaiming through that process. Unfortunately.
Well,
Is there a question?
you've been real troopers in the end. Oh, there's another one. Fantastic.
Sorry about this.
No, it's great.
Regarding the U.S. citizens that let go of their citizenship because of the FATCA, do they still have to register with the IRS and do all this process, or is there some time for them to...
The registration, just to be clear, sorry if it was unclear, the registration is by the firm, by the bank or the institution.
What about individuals?
The individuals don't need to register under FATCA, no.
I think what you're asking is, would they have to register in some form of disclosure program?
Yeah, the fact...
Yeah, I mean, technically, more than technically, they will have violated, the Department of Justice's view is they would have violated the U.S. tax laws while they were a U.S. citizen. So surrender your citizenship if you want, or still...
Otherwise, people's get out of jail free, no pun intended, would be just to surrender. Pay your exit penalty and then and rely on the fact that you're no longer the US citizen that you once were. That clearly won't fly.
All right. Thank you, everybody.
Thank you very much. Thank you very much for staying tuned.